The usually busy roads leading to schools in Kano metropolis appeared scanty as most schools were shut down ahead of the judgment of the Kano State Governorship Election Petition Tribunal. Amidst the uncertainty, heavy security is deployed to the premises of the High Court.
The situation in Kano today, because what we have been hearing, I did not allow my children to go to school because all the two parties, they are threatening themselves. Threatening if I don't get what I'm supposed to get. The heaven will fall, we kiss ground. That is why we fear. We did not allow our children to go to school. Even you can see our office is closed.
And based on what is happening around, there is enough security, so I don't feel any way. Whichever way it goes, it's safe. Kano is safe.
Moments after the judgment, supporters of the All Progressives Congress celebrate along Murtala Mohammed Way. Nevertheless, residents of the ancient city react to the judgment.
Unfortunately, it's not funny. And seriously, where the judgment is very, very bad. For 705 fuel this year, costly fuel. And seriously, the judgment is not making sense.
Everything in the hands of God.
Peaceful, even after the outcome of today's judgment, declaring Yusuf Gawuna of the All Progressive Congress as the winner of March governorship election. The council to the New Nigerian People's Party has said they will go further to the appeal court to appeal this judgment. For now, we can only watch and see what happens. From Kano Commercial City, Nancy Vincent, Channels Television News.
Thank you for staying with us. So that's where we are. The matter yesterday in Kano, well, reactions all over. There's a curfew imposed on the city of Kano and certain parts of Kano as well, just to ensure that peace is maintained. But to look at that judgment of the tribunal, we have here in our Abuja studio a senior advocate of Nigeria, Tribunal Akintola. Thank you for joining us.
You're welcome. Thank you.
And joining us virtually from Kano is Sanusi Bature, who's the Chief Press Secretary to the Kano State Governor, or going by the judgment of the tribunal, former, even though I know that they're going to court to appeal. But let's start off from there. Mr. Bature, that judgment by the tribunal, what exactly is the reaction of the Kano governor?
The judgment has been viewed as an injustice and unfair to the good people of Kano because we have a difference of over 120,000 votes, and the election has been declared within the confines of the law. Unfortunately, even before the elections, the opposition APC in Kano have been agitating that if we win, they will scuttle the election. And after the declaration, and they said our candidate, the NNPP candidate, will not be given the certificate of return because they will use the federal might. Fortunately, at that time, His Excellency Abba Kabir collected the certificate.
Okay, Mr. Kintola, the situation as we speak, now that judgment in Kano has come up and, sacking the Kano State Governor. Of course, the APC is happy and you're an affiliate of the APC, but you're first a lawyer. So let's look at it on the basis of the law. You think it was the right judgment to have come?
Well, you and I were not there. The judges and the lawyers that participated in the petition have the facts at their fingertips. What I know about it, because as an APC chieftain, the case in Kano, it doesn't come as a surprise. As a matter of fact, it is something that is not novel. I remember the case of Oshiomhole against Osumbo. That was the first time I had the privilege of leading that team. And most of the things that we had decided upon, that we are predicated, the decision was predicated upon, had to do with no signing, no stamping of ballot papers. About 150,000 was discovered in Kano at INEC office. And if that is the case, of course, such election will be nullified. And the ballot papers that were found to be invalid would naturally be deducted from the entire results. And it doesn't come as a surprise because I did that in Yedo, and that was the first time. The case of Oshiomhole was the first time that was applied. And of course, there was also the issue of new qualification, which the tribunal based its decision upon. And these are the little things I was able to gather from as the chieftain of the party. These are the things we were able to gather, and I think the tribunal judges that were there had the facts at their disposal. And not within the profits of my profession this morning.
To even win that.
We'll go into that because...
Okay. So this matter, before yesterday, for instance, the CJN at the swearing in of the new justices into the Court of Appeal was lamenting the level of litigations in the country of political nature. Isn't it too much of a weight on the judiciary that almost every election is decided at the courts?
Well, let me say this. The number of cases we're having now over the 2023 elections are not as much as that of 2007. But the unfortunate thing is that today, our judiciary is becoming too much media-driven.
How do you mean?
Yes, it's too much media-driven that it appears as if people don't have any other thing doing. Focusing on the judiciary, improving the character of the judges, threatening them, like what happened in Kano. For those of us who speak Hausa language, appreciate the level of the threat contained in the interview, the Hausa interview, granted by that commissioner that was relieved of his post. To me, that was just a slap on the wrist. I think something else should have been done to that commission.
So are you implying that...
And of course, the media encourages this.
Sorry, are you implying that nobody should look into or look at what the judges are doing?
No, that's what I'm saying. Judges should be allowed to do their jobs.
Okay.
But in this country, they have been threatened here and there. Look at what happened in the case of Kano. That the judges could not even stay there to deliver their job. They had to do it by Zoom. I mean, we should not encourage that.
Nobody's encouraging that.
See, a commissioner threatened the judges. A serving commissioner. And what happened to him was just removal from office. No prosecution. Our laws are very clear. You ought to have been charged to court. But nothing of such happened here. And of course, the media, and some of, even including some of our own colleagues, they will come to television stations. And I ask, what manner of lawyers go to television station Monday to Friday in the morning? As I'm here, my wig and gown in the car. So I'm going to court. What manner of lawyers have time to go to television station Monday to Friday? Oh, speaking of issues he knows nothing about.
But they may also be having their wig and gowns out there so that as they finish,
the point I'm making is that because you made a mention, of someone I came in here, well, some of us are not, we are not interested. We've been invited several times. But you have lawyers come to God, even bringing constitution law reports, citing authority in television stations. It's unethical. But these are the kind of things we are seeing now, that the media taking control.
Mr. Kintola, I do believe that the further state of the realm, that's the media, is meant to hold the society accountable.
Yes.
And that includes the judiciary and the lawyers themselves. Excuse me. Does that not count?
That law, that provision of the law, the constitutional provision that you have, that protect the media, has always been there. But I tell you, quite a number of things that are happening now. If you look at the situation before now, judges and lawyers and general have been jailed for this type of things that are happening now. And we have precedents. In the case of Kabir against the state, the top lawyer in Ibadan, the CJ of the whole West has jailed him. But what are we having now? They're not combating. Judges have been threatened, even right on television stations, on the newspapers, on pages of newspapers, and to us, we feel very uncomfortable. I'm sorry, that's why many of us have been very, very reluctant
to come out here.
Yes.
Let me ask you this before I bring in Mr. Bature. Is it not possible that the players in the judiciary, I'm using the word players in the judiciary carefully, have not been doing what they used to do, have also been compromised, unlike they used to be before now? Is it not possible that they have somewhat gotten into the mix instead of staying above board to look at things from above there? That's what's giving room for this threat, so to speak, as you say.
On the contrary, my brother, I would rather say that we are now having judges of timorous souls who are just too afraid. For instance, there is an election petition that is still pending. I will not want to comment on the facts. But because judgment has been given, of course, when an appeal has been filed. But let me say this. What we met on ground, the position of the law, so that cases are decided on pleadings. Some of the cases before the election petition are cases that ought to have died there the very first week if these have taken the position of the president in vogue. That is okay. Cases are decided on the basis of pleadings. And of course, cases are won and lost in chambers. You sleep on your bed the way you prepare the bed. If your pleading is so flippant, maybe get it out. We're not wasting time. And none of the cases that on the basis of the pleadings that ought to have died the very first week, it was mentioned. But of course, judges are too afraid to apply the law. If you are saying you have 10 polling agents in your pleadings, and of course, you are saying you won the election where you have 1,000 agents. On the basis of that pleadings, your case ought to have died there. In the past, when we joined this profession, we ask you to address it on the basis of your pleading. Look at your paragraphs also of your pleadings, address us on that. Can it sustain what you have brought before us? You see? Because our judicial system is acquisitional in nature. It is justice according to the position of the law, not justice according to how you feel or my disposition or my feelings. No. Okay, it's not about morality. It's not about what the public is saying there.
We'll come back
to that day never come.
Yeah.
When judgment will be based on public sentiment, public commissions, or what the media is saying. But that day never come. The country will be in trouble.
I'll say amen to that, but the judiciary should also know that part of their responsibility is to ensure that their judgment also does not in any way threaten the peace of society. Isn't that what's part of their responsibility?
You see, my problem here, when the media says, people are saying, oh, peace of society, where did you conduct the census of what are the scientific...
What I said was part of the responsibility of the judiciary is to ensure that their rulings do not.
That is why the Supreme Court is there as a court of policy, not just Just cut off.
We'll come back to this conversation. Let's bring in Mr. Bature. Part of what Mr. Akintola has talked about, he mentioned the fact that the judges of the tribunal were being threatened, and indeed, one of those that threatened them was just relieved of his duty and not persecuted, and that is contrary to the laws of the land. Shouldn't he be prosecuted? Hello, Mr. Bature.
Hello?
Yeah, we can hear you.
Hello, can you hear me?
Did you hear my question?
Okay, what is it? No.
Okay. I said Mr. Akintola raised the matter of threats to the judges, even though they have gone ahead to deliver their duties on this one, delivering their ruling as regards the election petition before them. He says they were threatened. That's why they had to do it virtually. Of course, we all saw that. But shouldn't that person that threatened the judges be prosecuted?
Well, the threat came from somebody and it's a personal opinion, and because of that, His Excellency the Governor has sacked that person, has relieved him of his appointment immediately, because a public officer should not be seen unguarded utterance. So the Governor should be appreciated for taking that proactive measure immediately. As the chief security. And then we need to understand that there are threats from different places, from the security forces, from the federal whatever. Hello?
Hello, we can hear you. You're saying there are threats from different places. Are there threats against the...
Exactly,
against,
yes. Because,
hold on,
yes,
let's clarify. Are the threats, besides this threat that was made against the tribunal judges, are there some... You said there are threats from different quarters. Are they also threatening the judges? Where the security forces, as you mentioned, threatening the judges?
Yes, I can categorically mention to you that we have the story of... the DSS arresting one of the judges last week. So that is not from the state, of course, you know from where it is. And there's no reason DSS can arrest any judge without any suspicion or anything. You understand? So DSS arrested one of the judges that delivered the judgment in Kano. And I believe that is intimidation. And even this virtual judgment they delivered, we don't know from where they are. Probably they might deliver the judgment under duress or whatever. I'm not sure anyway. But we don't know the location they delivered the judgment, and we don't know under which condition, because you can only see them in the screen, and you don't know what is behind the screen of the judgment. So a lot of things behind the scene, and to our surprise, the person that is declared winner is not even joined in the case. Gawuna contested the election, and after Kabir, the same Gawuna congratulated His Excellency and accepted the defeat. And he said he is not going to court. So Gawuna is joined in the court. And as a layman of the law, I knew that court does not give you what you don't request for. So in an ideal situation, he didn't go to court. He's not joined in the case. He's not interested in the position, because he knows that he has been squarely defeated at the polls.
Mr. Akintola, so in this case now, from what he said, the judges could, based on what he said, judges could have delivered this judgment under duress, but put that to one side. Then he talked about the fact that the man who's been declared the winner, who has been, based on the ruling, should be given the certificate of return, wasn't even joining the suit. How does that play out?
Well, to me, that's still remains a matter of speculation, but let's start from where he stopped. He said the fellow declared as the winner was not
joining the suit.
He has forgotten that the party that sponsored him was a party to that petition. And the fellow has not come out to say, no, he was not a party to this.
Would you, if you were in that fellow's shoes, would you come out and say you were not party to the suit?
No, of course. I mean, if I strongly believe in my stand, if you start acting on principle in this country, you may find that something near to my benefit doesn't mean that I'm going to embrace it. You see, it depends. And like he said, what he said is a matter of speculation to me. No basis for it, no fact. And to say that judgments were delivered virtually was wrong to insinuate that.
No, he did not insinuate that. He
that
said
was what
it's possible that they were also being threatened.
Which was also a matter of speculation, that it was possible, but it was not sure. And secondly, the lawyers that participated in the petition will have been contacted. This is not the first time judgments have been delivered virtually, even at the Supreme Court. I mean, judgments delivered virtually, had cases conducted virtually during the COVID-19. We conducted so many cases virtually, even at the Apex Court. And there's nothing illegal about that. But I do know that the parties will have been contacted through their counsel. If the counsel fails to turn up or hook up to the link, just too bad. But you will have been informed. And once you are given the link, irrespective of where they are delivering the matter, the judgment, whether from Calabar, Uyo, Badagry, or where have you? I mean, these are judges of the tribunal recognized by the Constitution. They have delivered their judgment. There is nothing that says that they must come to Kano to command to deliver the judgment, even the electoral act of the Constitution.
That matter about the threats to the judges themselves on both sides. Well, you were ready to respond immediately on that.
Yes, because he said, if you capture what he said vividly,
yes,
he said from security agencies.
And he also talked about the fact that one of the judges was arrested, that they have a report that the judge was arrested.
Has not been made public to my knowledge. And if that was the case, the appropriate authority will do the needful. The security agencies will prosecute the affected if they have any prima facie case against him, not on speculations. Anybody could have been arrested just by mere allegations. So I was on my way to this place. They say, okay, there's something in my pocket. It's the duty of the security men to say, oh, let's see what is in your pocket. So there's nothing bad about somebody, suspect being arrested and being released. If that is the case, to my knowledge, that has not been made public. And even the media has not reported it. He's saying that. I don't know.
Okay, my colleagues have questions for you.
Senior Advocate Akintola, what the media has made public, is from our sister political program yesterday, Politics Today, where the counsel to the NNPP said that the tribunal laid the blame squarely on INEC for failing to rebut the claims and allegations put forward by the petitioners on INEC. Some of the claims being over 1,000 polling units where there were claims of violence, overvoting, killing, disruptions, and that the commission called in only 34 witnesses. Now, unlike the other cases, which we can immediately draw example for now, the Presidential Election Petition Tribunal, where the petitioners complain about the reluctance of INEC to present, to give them access, rather, to evidence, and also the willingness of INEC being the respondent in this case to defend their case. Why this docility and the ease of access? There's docility on the one hand and ease of access to election materials.
Well, thank you, madam. You see, are you hearing me?
Yeah, go ahead.
The truth of the matter is that two cases might not be the same facts, the same scenario, the same portion of the law. It is not right to compare what happened in Kano with that of the presidential election petition. In the first place, INEC has the right to defend this election And if INEC find, this is not the first time that INEC will find that where it has no case, there was no basis for. In fact, in some cases, INEC has come out to say, I'm not holding brief for INEC. They are in a position to defend. The people of INEC are in a position to defend themselves. But what I'm saying is that this is not the first time INEC will say, no, this one is bad. Even there are cases where they even refuse to file defense. So it is not new, it is not novel. There's nothing spectacular about that stand. If INEC find as a fact it could not defend its position, the dignified thing for INEC to do is to stay away of probably.
But Dr. Akintola,
not prefer. Yes, please.
INEC conducted the election and it declared a winner.
Yes.
Shouldn't its character be consistent in every election, being that in line with electoral laws, it is a respondent in cases of election petition? So shouldn't its character be consistent?
You see, it is not in all cases. Let's face the fact. Like I did say, two cases might not be the same facts. The same. So many other things that right for people to stay out there and be speculating. We wouldn't know until we hear from INEC. It has its reasons for doing what has done in Kano. We cannot fault it if INEC found as a fact that it could not defend its position. The respectable thing for INEC to do was to throw up the sound like Pontius Pilate and say, look, I can't defend this. So I have not seen anything that is so strange about that. This is not the first time. And I'll give you examples of so many other cases that have come up that way. It's not in all cases that INEC will just have to come out willy-nilly, want to defend something that is indefensible. Don't forget that in that same judgment, the court found, the tribunal found as a fact that the petitioner found in the INEC office ballot papers that were neither signed nor stamped. And that was not the first time that was happening.
Okay.
Like I did say, the first of its kind was in Oshiomhale's case. So there's nothing strange about that. If you are caught pounds down, and like you people will say, if you, what else is there for you to defend?
Well, I struggle to understand that, Dr. Akintola, but if that's your position, we had another senior advocate on the program yesterday who says because of, these challenges, that in the future, if there'll be electoral reforms, that INEC should rather be an independent party rather than a respondent in cases, to avoid all of these pitfalls in the defense and, the seeming perception that it's taking a position. What are your thoughts on this?
Well, I will subscribe to that. That has been the position of my association, the Nigerian Bar Association, who have always been the vanguard of INEC adopting the position of a Wills report. And the MBA was adequately represented in that Wills committee, and we still stand by that position. So I subscribe to the opinion of my learned brother, because I watched him say that. Even may not have agreed with many other things he said, but on that score, it was another.
Okay. Well, let me ask Mr. Bature in our Kano studio, who has since rejoined the conversation. Mr. Bature, looking at some of the issues that were raised in that judgment, how is the Kano State government taking it? One of the issues raised was where Justice Osadebe ruled that even though membership of party is an internal affair, but the fact that INEC needed to prove that Governor Yusuf did not comply. Well, let me read that passage. It said, membership registration obtained from INEC clearly proves that Governor Yusuf did not comply with the Electoral Act, which required registration of membership 30 days before the party primary. What's the response of government to that?
Well, in a simple term, that is a pre-election matter and nobody challenges it within the party. So ideally, the only person that can challenge that that aspect is somebody who contested the primaries along with the governor, who is a member of the NNPP. And His Excellency contested this primary election unopposed, and he was affirmed by the party stakeholders at Thani Abacha Youth Center in Kano. So for us, that doesn't really hold water because it's a pre-election matter, and the court confirmed that it doesn't have jurisdiction to tackle that. But going to the other aspect of the judgment...
Just one second on that, before we move off, Mr. Bature, still on that same matter, while you are right, I mean, the court says it's a pre-election matter that shouldn't be adjudicated by the legislated, membership shouldn't be legislated by the court, but then the court also said that it is within the purview of any party to challenge such issues, just as the opposition party in Kano is doing at this time. So let me ask you straight up. Did the governor, during the primaries, did he register to be a member of the party 30 days before the primary?
Yes. I personally escorted His Excellency to register to NNPP at his Iso ward in Kano. And that was around around March 2022. So to us, that has been a surprise to say that His Excellency is not a member of the NNPP, because it's among the few 10 people that register as members of the party in Kano. Because as a political leader, he's supposed to register before any other person so that followers can follow suit. So at that time, I personally escorted His Excellency to his ward to register as a member of the NNPP. Then a day after, I also go to my ward in Dawakin Tupa to also register. So it's interesting.
That you put it that way, Mr. Bature, particularly when this one is coming from the courts, and I'm suspecting that there must have been some evidences before the courts that said contrary to what you are saying now. Don't you think so?
Well, manipulation happens everywhere, my brother. So I, as a politician, I cannot be surprised to any manipulation, and the court can only discuss about what is brought before it. You understand? So even the voters register that they said is amended or it's brought to the INEC before the election. It's really a surprise for me. I don't know at what point manipulation happens, so I don't want to really discuss further.
Well, you wanted to speak about the other issue, which perhaps has something to do about the lawful votes that the tribunal held, did some recounting and then came to this particular submission. How is the government receiving that particular one? Because there are those who will be wondering, how that came to be.
Yeah, first of all, I want to say that what the judges did for the APC is beyond what their lawyers and their witnesses can do. The APC said they're going to bring hundreds of witnesses, and they were able to bring about 32 only. And then some of the witnesses at the cross-examination denounced what they written in their deposition of witness. But to our surprise, most of these witnesses are accepted by the court. And then the issue of recounting and the issue of that relates to that issue of unstamped ballot papers. The surprise we got is that the judges selected, or the judges accredited all the unstamped ballot papers to NNPP. And I am very sure that within over 100,000, 160-something thousand ballot papers that are unstamped, there must be others for other political parties, particularly APC. So why couldn't the judgment relate to, removing some from the NNPP and some from the APC, but none from the APC? They deducted the entire unstamped ballot papers from the APC, NNPP votes so that they can give advantage to the APC. So this looks like a drama, and I'm very sure a lot of people are commenting on that. I've seen so many essays, and even in Channels Television yesterday, that you guys featured, and they really express their shock on that.
Mr. Bature, are you accusing the judges of just 1 second? Are you accusing the judges at the tribunal of partisanship?
Well, not really a partisanship, but this is entirely an unfair judgment. We have said it, His Excellency has said it.
Because when you said, just a second, when you said that they favored, as far as you're concerned, the judges favored the APC against your party, that's why I'm wondering whether or not you were accusing them of partisanship.
Well, we cannot call it partisanship because they are not politicians in any way. But what I'm trying to say is that the judgment is tilted towards one side. And one side for the fact that we are leading with over 100 votes, and then they went into that argument of unstamped ballot papers. And to us, unstamped ballot papers that are accepted by presiding officers and accepted by all party agents and security agents is valid. So therefore, going back into that issue is another also legal thing that we are going to challenge.
Just let me get this straight, because I'm still going to ask Mr. Chief Akintola about that one. When you said unstamped ballot papers that are accepted by party agents is valid, is that what you're saying?
Yes. Because election at the polling unit is managed by the presiding officer and with the party agents. So it's not our fault. It's not His Excellency's fault that there are some unstamped ballot papers. Because as candidates, we don't manage election. We don't manage the process of the election.
So how do you respond to those who might say, well, you're speaking like this because the governor, your governor, is the one that is in office now, and when you say unstamped ballot papers are valid because other people, accepted them, what if some people come and say you or your party induced them one way or the other to accept those things and just sign and say it's okay?
Let me tell you, when the election was held, APC has the federal government, APC has the state government. So they are way at an advantage over us in terms of influence. And then if you're talking about one particular thing that is cut across many local governments, the issue of unstamped ballot papers, there must be an unstamped ballot papers that voted for APC. So also that voted for PDP and for NNPP. Okay. Why is it that only those that affect the NNPP are recounted and withdrawn from the total votes to give APC advantage?
Please go ahead.
That's the fundamental question we are raising, and it's going to be challenged at the appeal. All
right. We'll take that to our studio in Abuja. You've heard him, sir. You heard everything that he said. First of all, the fact that unstamped ballot papers numbering more than 165,000 were considered legal so long, or rather should have been considered legal so long as party agents agree. How do you respond?
Is the question meant for me?
Yes, sir.
Okay. Thank you, my brother. The truth of the matter is that you agree or illegality doesn't make your action that's called valid. Even if you and I agree to do something that is illegal or something that is criminal, that will still not avail us the chance of freedom from prosecution. When you look at the issue he raised, the issue of unstamped and unsigned, like I did say, it is not novel. It's not the first time that is happening. And when such votes are deducted, it's anyhow to the disadvantage of all the parties involved. Because look at the argument, even the argument he preferred shows clearly that he admitted the fact that those ballot papers were neither stamped, nor signed, nor authenticated by the relevant INEC officer. So the mere fact that there are agents there that assisted to that illegality doesn't make it valid. We are talking of the provision of the law here, of the Electoral Act, and the Constitution here. If something is patently illegal, it is illegal. There's nothing anybody can do about it. So you can't say because a 30-year-old girl is your daughter, and you have carnal knowledge of her, and she's not complaining, you are not complaining, and the law cannot take its course against you. No. You see, the truth of the matter is that the Electoral Act prescribed ways of conducting election. And if no stamping and no signing and no authentication of the ballot papers are part of the conditions stipulated in the Electoral Act, so be it. There's nothing anybody can do about that. If you don't comply, you're out. See, thank God we have said that the party involved, its own government will approach the higher court. You still have 2 layers of courts to ventilate their grievances, and of course, if the court so found that the no stamping, no signing of the ballot papers makes the ballot papers illegal, there's nothing anybody can do about it, if that is the position of the law. It's not about your emotion, it's not about your thinking, it's not about your feeling. To me, he's been expressing his feeling here. That's not the law. And that was what Lord Denning pointed out. It's not the emotion, it's not the feeling of the man of it. No, it is the position of the law. If you don't like the position of the law, go to the parliament and change it. I am putting the blame at the doorstep of the parliament. People start putting the blame at the doorstep of the judges and INEC. No, it doesn't work that way. If you don't like a particular issue, a particular legislation, speak against it, go to the parliament and make sure it is changed. And that is why those of us who are saying, ways report should be followed, hook, line, and sinker, let us have, let's unbundle INEC from certain things, sticking to our position that INEC will be made to account for its action in election petitions. But where INEC is made a party, INEC has the right either come out to defend. It's your right, constitutional right, to refuse to defend an action filed against you. Of course, judgment will be given against you. But for not saying anything, it means you have admitted that much. He has admitted that, of course, they found as a fact, because when inspections are conducted at INEC office, I've been involved in that several times. All the lawyers to all the parties are usually present there. They will be given a date at the time, and the number of lawyers expected from each side, they will be there. They will all see what is being inspected. And as soon as that is concluded, the report will be filed. The form part of, that's usually done even during the pre-election period, pre-trial period. So, and to say that the issue of party membership, that he followed the man there, of course, it is the document available to the tribunal. The tribunal will make use of, not what you are saying verbally, because you are not there, I was not there, so I cannot verify that. But the documents, and in any case, people have forgotten that you don't need to call community of witnesses in election petition, or in any case at all. If there are documentary evidence that will justify your position, and of course, documentary evidence speaks for themselves. If there are documents and you do not produce any other document that contradict that, you have been admitted. If you want to impugn a particular document, you have to provide something that is contrary to that document.
As we wind down here, just weighing on this, an advice from the CJN. I'm taking you back to the CJN and what he said yesterday about the reduction in litigation. Let's find other means of alternative dispute resolution mechanisms to ensure that litigations are minimized and the load or workload on the judges is reduced to the barest minimum, especially political cases of political nature.
Well, I agree with him. With his Lordship, my Lord, the Honorable Chief Justice of Nigeria, that, like I did say, But there are quite a number of things that we have to put in place. The Electoral Act has to be rethinked again. You just have to do some further surgical operations. Don't forget that the amendment to the Electoral Act of 2010 came about as a result of judicial decisions. So it was governed by judicial decisions. And what we are expressing now, of course, we put the stakeholders on their toes to look at areas that needs further amendments. Besides that, there are alternative methods of resolving disputes, like, as already pointed out by its lordship, the CGN, but a lot still remains on the part of our judges. Like I did say, cases are decided on the state of pleadings. There are some cases, some election petitions that should not go beyond the first day of hearing. Based on the petition or the pleading before the tribunal. Right. But we've seen a situation where, because of the provision of the Electoral Act that says if there are objections, leave everything to the end. There are some objections that are so fundamental that no petitioner can defend it. That should not even waste the time of the court and resources of the court.
All right. Thank you so much. Thank you. Mr. Adeni Akintola is a senior advocate of Nigeria and who joined us here in Abuja studio. Thank you for coming in this morning.
Thank you. It's my pleasure.
And joining us virtually was Sanusi Bature, Chief Press Secretary to Kano Governor Abba Yusuf. Thank you for joining us.